Hey everybody, thanks for being on. I want to do more of these things where we have people like Connor and other folks that can help kind of guide what's going on in the industry and what to do for companies who have visits from the Department of Health. Connor, I know, spoke a week ago, I think, or 2 weeks ago. I can't remember. It seems like time's flying real fast at the Medical Advisory Board for the legislature and Department of Health and Department of Revenue. Um, and he talked about a lot of the things going on in the industry with fines that are coming, inspections that are happening from the Department of Health and Revenue. So I figured now would be a good time for people to start having that dialogue. And Connor, I know you have a lot of clients who have come to you with issues, and you can take it away from here and talk about what it's like in the industry from your perspective.
Thanks, Ken. Can everybody hear me okay?
Yeah.
Cool. All right. Ken, thanks for having me on, everybody. Appreciate your time today. I just wanted to give everybody a little bit of some insight as to what we're seeing with the state agencies dealing with medical cannabis companies. We are a small law firm in Mississippi. We specialize in working with clients in regulated industries like alcohol and food manufacturing and now medical cannabis. So we see a lot of the same approaches to regulatory enforcement across different industries, and have done this for years and others. And now we're doing this in medical cannabis, which of course is evolving very quickly, but it's going really well. What we can see, I mean, frankly, what we're seeing in this industry is very similar to what we see in other industries in Mississippi, and when you look outside the state, it's actually better in some respects. And I'll give you some more details there, but today I wanted to cover some stuff. Some of the things I'm going to say, I talked about, as Ken said, in front of the committee a couple weeks ago at the Capitol. Other things may be new, and I also wanted to address, in case somebody's joining, that you've recently been licensed. I know we when I spoke a couple weeks ago, it was more like assuming that people had been licensed since last year and now you're up and running, but it also may be that you just recently got a license and you don't even really know what could be coming down the pipe. So with that, I'm not going to go into excruciating detail on how this is regulated, but as you all know, both DOH and DOR are very active in regulating this industry. Department of Health has the primary responsibility of it. Department of Revenue comes in more specific on dispensaries, which, if you've ever dealt with Department of Revenue getting an alcohol permit or a restaurant, liquor license, things like that, they're very focused. They have an entire arm of enforcement. They have an enforcement division that spends a lot of time sending folks out in the field that have a lot of experience in enforcing their regulations, catching minor violations or major violations, and then issuing fines. So that is tracking with what we're seeing right now. They are treating cannabis very similar to how they're already enforcing their other regulations in the Department of Revenue. Not a phrase that I came up with, but if you're a hammer, everything looks like a nail. I think that's sort of the situation going on with DOR right now. Not that what they're doing isn't justified, but we're getting a lot of calls from clients who are getting number of visits from DOR agents that are visiting their facilities and then issuing them warnings and then citations. We're going to talk a little bit more about that.
Enforcement talking about us is that, like basically they're a hammer and you're a nail, and they're looking to get you. And he said they've been doing this a long time and they're really good at what they do.
Thanks for that. Yeah. So let me just kind of go back to what we're seeing right now. Licensure that really occurred last year, that the ramp up period in licensure was their focus was on getting folks licensed, right? So their staff, a lot of their staff at the time was taken up getting people through the licensure process, right? Now that I would say the bulk of folks have gotten licensed or even now renewed, they're turning their staff time into more on the enforcement side. Department of Health in particular, so you guys probably remember this, last year they had very few staff, and I feel like everybody was there to help with licensing, and then some with the patient cards. And now they've gone through some staff changes, not only at the top, but kind of all the way down. So there was some turnover there, which you may have been involved in or seeing how that was going down. Then secondly, now they've got enforcement agents, compliance officers, a handful of people that that's their job. And much like Department of Revenue has an entire Department of Enforcement, DOH has a handful of folks that are doing it, and each agency has sort of their own methods of approach. So going through that a little bit, if you are newly licensed, you are going to have a visit at some point. The Department of Health will show up. Typically within 30 days of you getting a license, they are going to do a site visit. They're trying to check to make sure that your site, among other things, matches what's on your application. Look at their diagram. They're going to make sure that all your security cameras are in the right place, that your doors are locked the way they're supposed to be. They're definitely checking for work permits and having it on your person. They're checking all these things. And I will say Department of Health has been really great about having some leeway on that, right? They seem to be very understanding of folks that are just getting into the business, that may not fully understand the gravity of being in a regulated industry, and that there's a lot to keep up with. But they're getting even better about providing real-time feedback on what are the deficiencies. So Department of Health will they will pay you a visit, and then they will follow up with a document. They'll send you an email to the email on file and give you some items requesting a corrective action plan. So if you haven't gotten one of these before, you're fortunate. But frankly, this is the best thing that they could have done. I really appreciate they send these documents out, talking about what they saw. They document, what the issue is. They cite the regulation that they see there is as a potential violation, and then they request something specific that you do. It's not necessarily that, oh, and you're automatically fined. It's generally like, hey, this was, these plants were not tagged correctly. This is the regulation that spells that out. This is what you need to do differently. And we want you to write down and show us how you're going to do this differently. And that may seem like a burden, but the fact that they're not just slapping you with the fine right out of the gate, I mean, that's to me, a huge win. And I really appreciate this, because at that point, my clients call me and say, hey, we got a visit. Now we got this, we got this follow-up email from the Department of Health. What do we do about it? And then we start going through it. And like I said, they list out, and they could be everything from, you don't have your doors are not properly locked. You need new locks on those doors. Or it could be, you had a security camera marked here on your diagram, but you don't have it where you said it was. Great. Those are easy fixes, right? More complicated is what we're seeing more often is that you've got, you've got deficiencies in your SOPs, right? You may have written great standard operating procedures for a variety of things, but if you don't have those SOPs on site and your staff are not trained to know what they say and they're not following them, well, then the department looks at your SOP, which they have on file, and they look at how you're operating. They go, well, you're not doing what you said you were going to be doing. And they want you to amend your SOPs and then, clean up your act or whatever it is. Again, though, this is a great small step. They could just say, well, sorry, you weren't following the SOP. There's a fine. So this is an opportunity for them to explain to you what the issue is, for you guys to understand it, and then make some changes. Though I will say, though, that some of the things that we have seen in these email documents from DOH, we may not agree with, right? It may be an interpretation of the regulation that needs clarification. I think everyone here is, if you've read the regulations at all, you know that there's a lot of deficiencies there. There's a lot of gray areas. There's a lot of terms that are not defined. There are plenty of instances where it says one thing specifically, and then the way that the DOH interprets it is not written down. It's just not there. And I will say they're aware of that. This is not something they're not aware of. They're aware of that. Largely, those are documents that were drafted last summer, and now the programs have been running, that things have changed, and that they're looking at documents and they're going, well, is this actually how this works in practice? And they're currently working on some amendments to those regulations. We thought they were going to come out a couple weeks ago. They have not been released yet, unless they were released this morning, and I've already missed that. But there should be the next couple days or next week a revised versions of all of the regs in the Department of Health. So if you haven't heard that before, make sure that's on your radar, that you're looking out for it. I know Ken and the 3MA team will be keeping everybody apprised of changes to the regulations, and that everyone needs to be up to date on what those changes are, because some of the stuff I've heard really good. It's just clarifications on things, and also others is outright changes to what some of their approaches. But that's what we've been asking for this whole time, and I think we'll continue to ask for is revisions to the regulations to make things more clear. People need to know what are the boundaries. What do I have to do? What is this? What are you really wanting me to do here? And if it's gray, that's not helpful, because then you guys get frustrated. We disagree with the department, and then, maybe even get into a back and forth about what it really says. So some of those things that we've seen through the Department of Health in particular, the biggest one is metric. I mean, I think everyone knows that. The biggest is incorporating metric into practice here. Metric operates in a number of states. I don't remember how many, but it's quite a few, right? It's a majority of states that have medical cannabis programs, and they have their own, general back end of how you use metric, right? And that's how you access that through the metric user guide. You can see that. Then they have a supplemental guide that's specific to Mississippi, and that's Metric as a third-party company trying to come up with processes for doing things that fit with the regulations. Well, now you're going from a regulation that's can be kind of wonky to Metric user guide that's being updated somewhat frequently, and that's hard to follow. So we are seeing a number of citations, or at least requests of a corrective action plan related to metric. In particular, there was a lot early on, and we're still seeing a little bit of that about how long plants have to be tagged. When can you remove that tag? When does the tag follow essentially items to be disposed of, and when does it remain with, say, a harvest batch? I think a lot of that's been cleared up, at least with my clients. We've gotten some direction from the Department of Health, and I believe that's coming in these new regs is some clarification on exactly when you should keep the tag with plants, et cetera. So that's super helpful. Again, we just need to know what the boundaries are and what's expected. The one that we do keep seeing for especially new licensees is lacking ID cards. Folks walking around a facility that maybe they work there, maybe they don't, but they don't have ID cards. They don't have a badge on. That's easy fix, but something that you want to try to avoid. If you've got employees, you need to get them a work permit. I mean, that's one that I think the Department of Health is going to have, and the Department of Revenue are going to have less and less tolerance of. Right? Some of these more complicated matters, maybe, but as we get farther into the program, some of these things are going to have less tolerance of, and they may just hit you with a fine. So make sure.
He's talking about finding people without tags around the neck. He's talking about finding people without tags around the neck.
Does everybody mute your phones? By the way, we could. If you have a question, we can put it in the chat box or save them to the end. I'm going to be open to questions here in just a little bit. Make sure you mute your lines. Thank you. The security system one, I've gotten this one so many times recently. Like I said a minute ago, people that maybe you bought a system, you didn't quite install everything, but you've got a diagram on file with the Department of Health that says where all the cameras are going to be. And when they show up, they're going to just look around the room. They're going to count, and if they don't see what is on the diagram, then that's an issue. Same for dispensaries. And the dispensary side is, like I said, they're issuing citations for those. They're not giving you a chance to correct that. All things that you can correct, right? These are the approach of the Department of Health is give you a chance to correct it. The Department of Revenue is a lot more aggressive. What we're seeing there is they may show up and you have not inputted something into metric correctly for a number of purchases, right? There was issue recently with calculating the amount of MMCEUs between flour, and then you convert it to other products, and some discrepancy there about using certain third-party software. And the department's kind of like, well, we don't really care. You 16 situations that you inputted the incorrect amount or overrode it or something. So multiply that times $5,000, and that's what you're going to owe us. I mean, that's a lot of money. I don't care where you come from, and that's enough to cripple a business or put somebody out. I've got an issue with that, and just in general. One, what we're going to be asking the Department of Revenue for is more of an approach like what DOH does, which is a written summary of the issues and an opportunity to correct. That would be a great first step. Hopefully they will do that. If they're not willing to do that, we'd also request they don't use the maximum amount of a fine for every little thing. I mean, a $5,000 a pop. I mean, if you look on their schedule through the regulations, they make it a schedule. Like all of these violations are $5,000 each, right? Well, they don't have to be $5,000 each. It says the law says up to $5,000, right? They could do it for a much lesser amount. I would imagine that they're doing this so that they, are scaring folks into compliance by scaring you from a dollar.
Yeah.
But at the same time, maybe that's a little harsh, right? I mean, some of these things are not, folks aren't trying to break the law, right? They're trying to follow the law. There was, data entry incorrectly. It doesn't need to result in a $5,000 instance fine. So, I think there's some room to grow there.
Hold on a second. Whoever that iPhone Almy McLean is, you need to mute your channel. Everybody can hear you talking over Connor.
Hey,
Sorry, Connor.
Trey McLean, can you mute your phone?
We don't.
All right, there we go. All right, good deal. Okay, so let's say that somebody shows up. What do you do? Well, first and foremost, you, the owner, or somebody in charge needs to be the one communicating with the agent. It doesn't need to be your, a bud tender or someone on your grow team, right? It needs to be you. My recommendation is it needs to be someone with authority, because it's your name as an owner. Your name's on the license, right? If there's real problems, they're coming to you. They're not coming to your employees. So it needs to be you communicating. Two, I recommend that you keep it as cool as possible. I can't tell you how many times people have called me. They're mad. They don't agree with what, an agent is saying. They want to argue with them about something, or get hot about it. And I know it's easy to do when you're under pressure and you've got a business to run and this now an interruption, et cetera. But it's just like any visit from law enforcement. Don't bow up. Don't try to have an argument with them. Best thing to do is to document the interaction. Get their name, try to find out why are they there? What specifically are they alleging that you have done? Ask for that summary from them in writing, and, ask that you can, consult with your business partners or attorney, which I would recommend. That sounds self-serving, and it is, but call your lawyer. If you don't have a lawyer, you need to get one, and call your lawyer, and you can figure out how to respond. You don't owe them a response right there. You don't have, it's not, this is, unless you're, actively selling cannabis out the back door illegally, they're not dragging you off the jail right there. They are gathering information. Oftentimes they are looking for more information to then put together a potential, citation against you. But my recommendation is comply with it. We can always work on it on the back end if you don't agree, right? Just don't have it out with them in the middle of your store. That's never helpful. Most of the people you're dealing with are enforcement agents. They're not attorneys themselves. They are law enforcement of a sort. Some of them are actual law enforcement. And they're doing their job, but if you disagree with what they're saying, there is another layer above them that we can work with, if you disagree, and whether it's formal or informal at that point. If you get a formal citation or a warning or a corrective action plan, again, I'd highly recommend you have somebody involved that takes this seriously. You've got to pay attention as a business owner. This is not messing around. You could lose your license. You could be fined a whole lot of money. So don't ignore it. Don't forget the date that they want you to respond by. They have dates that you need to respond by. Don't let it pass by. You need to address it right away. And our experience is the sooner that you jump on this, the better. Because if you disagree with something that they have said, let's just say it's a citation for a violation related to inputting something in a metric, for example. There's a lot of gray area there, and I think this is a good opportunity to continue to talk with the Department of Health, or in the instance of DOR, to have a more candid conversation about it, and to follow up with them and say, look, you cited us for all of these things, and we don't necessarily disagree with some of these, and this is how we're going to change, right? We're going to, make sure this, and this happen. But this one over here, we don't necessarily agree with that, right? We don't see it the same way you do. can we at least have a conversation about that? And I've found that the Department of Health is very open to having those conversations, right? I'm not saying they're going to agree with you. I'm not saying that you're going to get off the hook, but at least clarifying so that you know going forward, and that the industry can understand going forward what is expected of them. And but sometimes it's true. It's a sit down, we go through something, and it's a, well, maybe we were looking at this, maybe they were looking at this wrong, and can come up with some sort of agreement with the Department of Health as to the appropriate next steps that are maybe not a fine, right? If to me, if the goal is, if the worst case scenario is you lose your license, all right, well, we're not going to go there. If the next is some big fine, well, if we can get you off of that, even better. But if the violation is based on something that we can discuss with the Department of Health and come up with a solution that doesn't involve a fine to you, and can get you where you have to change, right? I'm gonna change the process. We agree that maybe there's some gray area here and we could do something differently. This is how we agree we'll do it going forward. We will put it in writing how we're gonna do it differently from now on. That's a good outcome, right? That's a really good outcome. Even if you have to change your process in your grow facility or processing location. I mean, those are all good outcomes that don't result in a fine or even worse. So we always try to work towards that. And I found that if you approach it with that in mind of, maybe I'm wrong, but maybe there's something to work on here. The Department of Health has at least been open to that. I appreciate that. Department of Revenue, we've had fewer interactions with. I mean, they've been definitely issuing a lot of citations right now. And I think that it's coming up to probably a head soon of needing to do a sit down and sort of go through what they're finding folks for, and how it's being done. And they've also gone through some changes over there on the staff side. So I think it's time to and we've been talking to them, it's like we haven't, but talking to them more in depth about the way they approach enforcement, ensuring that the regulations are clear and that they're not overstepping, or they're also not being heavy-handed on enforcement, because that's also, I mean, that's just not necessary, right? It's as I mentioned a couple weeks ago, in any industry, generally you've got 5% or less of industry members of any industry or licensed businesses are ones that look for ways to skirt the rules and break the law, et cetera. The overwhelming majority of people in this industry and everything else are trying to follow the law, right? They're trying to follow the regulations, and not trying to actively, skirt the system. And so, if you're going after everyone like they're in the same category, that feels a little much, right? It feels a little hard. And so we ask for a little leeway with the Department of Revenue, and hope we can get there as well, like the Department of Health has done, which is super helpful. But let's just say you get a visit and you get a citation and you disagree and they don't change their mind, and you were issued a fine or a suspension or worse. So what do you do there? Well, both in the Department of Health and DOR regulations, this comes from the law itself. It's a process for appealing that decision. You can tell them that you disagree with their assessment. You can file a petition for appeal. Both agencies have a process for that. They have a form you fill out that you have to do within 20 days of getting your citation or whatever the corrective, whatever the disciplinary action was. You file this petition for appeal with that agency. Both agencies have a system where they have essentially a hearing. They have a small hearing. It's in private, and they have a hearing officer there, and they have folks on their side who review the situation. And you have an opportunity to bring an attorney with you, kind of like going to court, but it's a lot less formal. It's just very informal, but there are rules that surround it, and there's opportunity for you to make a case to potentially reduce or even reverse your I could say sentence. That's not really what it is, but whatever the discipline action is that they've imposed on you. The likelihood of that, of prevailing there, might be low. I mean, their review boards and the groups that are reviewing the staff decisions. I mean, generally speaking, if you've already made it through, talking to the agent, you've already made it through trying to work on this informally, and you still disagree, and then you want to press it. I feel like they're kind of rubber stamping the decision of the staff. Not a lot of, I don't foresee a lot of positive outcomes there, though it's not, it doesn't mean you aren't going to prevail, but maybe not. So you're going to spend a little time there going through that process if you disagree, and they may uphold their decision. If they uphold their decision, you're still not done. If you disagree, let's say they revoked your license, and you disagreed fundamentally with why they revoked your license, then and you lost at the review board level, then the next step is for you to file an appeal in the circuit court in the county in which your business is located. This is a little bit different because a lot of these used to be where you file an appeal in Hinds County, where where the health department is located and the Department of Revenue is located. But here you actually go to the circuit court of the county in which you are located, which is a little tough because it sounds good and in theory it could be good, but you're also taking it to a court system that is likely not familiar with any of these things, right? They don't know anything about the medical cannabis industry. They don't know anything about the regulations. So you have to bring them up to speed in your appeal on all of this stuff, which means engaging a lawyer and drafting a lot of documents and pleading your case to have an agency's decision overturned. It's possible, and it does happen, and it has happened in other industries with other agencies for a long time. So there is some precedent there, but just knowing what you're up against, and how long that could take. And you're looking at, if you file an appeal to circuit court, you're looking at a minimum of 8 to 12 months, and I don't know, anywhere between $50,000 and $100,000 in fees just to fight something. It's a lot easier if you back that up and don't even get to that far. You come all the way back to working with an agent and working with the agencies to see if you can come to a resolution there. Even easier, just follow the regulations and try to keep your nose clean. Unfortunately, there are situations in which you've done everything right. You feel like you followed the regulations, you've done everything correct, and you still get popped and you still lose, and you've got to fight it. And that's a tough position to be in, where you have to spend more money on legal fees to try to get you out of something that you feel adamant that you were following the law or the regulations on. And that's tough. You're going up against an agency that has as much resources as they want. They're not as concerned about an appeal because it's not, I mean, just speaking frankly, it's not like anybody of them are going to lose their job or lose a business. It doesn't, it's not up to them really. So, I think the incentive is there for them to, you're going to fight it. Okay. They'll fight it. They'll fight you on it. So it puts a lot of the burden back on you as a business owner to decide, well, how far am I willing to take this? And so we try to help our clients figure that out. Like, all right, let's really play this out. If you want to fight this, this is what you're looking at. This is how long this is going to take, as opposed to agreeing to take a fine now and then just change how you're doing things, right? I mean, taking a $5,000 or $10,000 fine may sting now, but could be way better than dragging something out for 12 months to end up at the same position you were already in and then be out of a license or worse. So, that's a decision you have to make with your lawyers when you're looking at, how do you approach a disciplinary action. But there is a process here, and I recommend you work with someone that can, guide you as to how to fix these issues. And as a new program, there's gonna be a lot of this over the next couple of years. These regulations are changing, the staff are changing, everyone's learning, and because of that, there's a little bit of rub right now, and it's going to get better. I think the regulations are getting better. The relationships with the agencies are getting better, and but in the meantime, you've got to kind of power through. But that's it for me. I wanted to keep this short and then open up the questions. Ken, did you want to take it back over for a second?
Yeah. Connor, I have 2 questions before we start asking everyone, and we've got plenty of time for people to ask questions of you. One, what happens when someone gets some kind of disciplinary action and they appeal it in the interim? I mean, do they go about it business as normal? Do they have to put a pause on parts of their business? Tell me about that.
Great question. It depends on what the violation is and how the department approaches that. So in some situations, it could be that you've been hit with a fine, and they're going to allow you to keep working, keep your business open, so long as you don't do X, Y, Z, right? Whatever it may have been as the alleged violation. And in that situation, like, right, let's say it's a grow facility, and you're in the process of sorting out whether you really did violate a regulation or not. They may allow you to continue to grow. You're not like instantly going to go out and destroy all your plants or something, or or not allow anyone into the facility. But I think that's very fact specific, right? I mean, it wasn't what you're talking about. If if they walk in and it's a situation where no plants are tagged, no one has work permits, you're selling out the back door, you're violating multiple, portions of the regulations. They may say, no, you got to cease operations right now. We're not going to let you. Your violation is so egregious. We're not going to let you keep operating. That's pretty rare, though, right? Everything we've dealt with so far, it's like, no, we're going to allow you to keep growing. You're not going to have to destroy anything, but we're not going to let you harvest yet. We're not going to let you plant again until X happens, right? So it usually comes with some conditions. I've not seen that on the Department of Revenue side. I don't know how they're approaching dispensaries, whether you can keep operating. Again, I think they have discretion. They have the discretion to allow you to keep doing it or not. But it's sort of like you're doing things at the same time. You are still running a business and you're still fighting whatever it is politely while you're trying to maintain a good relationship with the agency. So it's a little bit of a dance there. And again, it's very specific to the alleged violations. So.
And then, how successful are most, that as you know of, and hopefully we'll be able to get some more concrete data from Department of Health and Revenue without sourcing names of businesses, of how successful things have been. But in your experience, how successful have people been in pushing back against, they say you have a violation, so here's a $5,000 fine, and you say, well, no, and I don't think that I actually violated that regulation or that rule. How successful have people been at that?
Well, you've got two camps. I mean, with DOH, just to speak candidly, I have found that they are a lot more open to discussion about issues with their regulations, and whether we ultimately are right or wrong, it doesn't really matter. I mean, if it's at the end of the day, if they ask you to make some changes, like I mentioned earlier, then that's better than paying a fine. So, candidly speaking, I would say DOH has been much more approachable in working through issues. And I'm not insinuating that they're like cutting people deals or like bending rules. I'm not saying that at all. It's more of it's like their first time with experiencing an enforcement around a particular issue and having a discussion about, well, all right, we're reading the same section of regs. This is what this means to me. What does this mean to you guys? And we realize, wow, we are not looking at this the same way, even though the words are the same. And we've been very successful, at least walking out of those meetings with a better understanding of what they're asking for and not having to have destroy your crops, right? I mean, that would be the worst case scenario. So, or one of the worst case scenarios. So good outcomes there. I've only had one with DOR, and it was a pretty big one, but it was a good outcome at the end of the day. All these fines that people are getting, these warnings, what I've seen over the past 2 months or so is a lot of these warning letters come out to dispensaries, and they're warnings, and then they're requesting data and other evidence from the dispensary, and they're sort of I'm not saying building a case, but they're evaluating how they're going to come down on something, right? They've not actually issued a citation yet. So it's a little early for me to say that on the DOR side. I've got a number of clients that have sent me I've got this warning letter. I'm like, well, there's nothing we can do about it right now. Once you get an actual citation, then let's talk. Because we don't know how they're going to come down to it when they actually look at, when they actually make an evaluation and decide, okay, are we really going to hit you with 16 violations of this, same regulation or not? So I don't know that yet. I'm hoping that they are, receptive to some corrective action plans at that point, and not just, no, this is what you owe, send money in to the Department of Revenue to the tune of, $240,000 for all these violations or whatever it may be. So time will tell there. I think it's too early to say.
Well, those are the broad questions that people have asked me several
Okay.
times over the past couple of weeks. I know we have plenty of time, so I want to open it up. If anybody does have questions, feel free to unmute yourself and ask, and then I'll remute you after the question's asked, or put it in the chat, and that way everybody can see it and it's easy to answer.
While everybody's thinking of a question, I will take an opportunity to just also say that the people at these agencies are not evil. In fact, they're much nicer than that. They're nice folks. They work for state agencies. They're in a new program. It's a lot for them to take on and to like, they're not private businesses. So they can't move as quickly as all of you can. So there's like we identify a problem in their regulations. It's not like they can just draft a change, and like they have to go through so many layers of approval. Things take forever. And this is going to be an ongoing thing. And I would just ask that, I like the people over there. I mean, we've had our differences on certain times, but generally speaking, they're good folks. They're trying to protect the public. Their approach could be different depending on who you're talking to over there, but just keep that in mind as you're operating too.
And there are several things that are in the regulations and several things that are in the law. And while regulations take a few months, usually between 4 and 6 months to change, the law is only touched for 3 months every year in the first 3 months of the year. So that's another thing that I get asked a lot is, hey, can we fix this? Can we fix that? And I say, sure, but we have to wait for January because only our legislature can fix that problem. And then when it comes to regulations, it's when the department seems to get either Department of Health or Revenue, when they seem to get a critical mass of problems with regards to one regulation or a couple of regulations, that's when they start addressing them in the correcting process. It's not, hey, here's an issue and only 3 companies in the state have had the issue. They typically don't address it in regulation. They work, especially for the Department of Health, they try to work something out in the interim.
Yeah, and to that I'll say that's why 3MA is a great funnel for your issues, right? You take your issues, you gotta, you guys talk amongst yourselves a lot about, oh, I'm seeing this or I'm seeing that. You gotta aggregate those and then form a plan as to what you're gonna ask for. And trade association is a great way to do that. But you gotta give them the information. They're like, this is what happened. This is what we're seeing. This is what we're concerned about. And if enough people are, having that same problem, then yeah, there's likelihood you get a change. But it's a lot easier to go through and everyone pools their resources that way than to just, if you call up the DOR and just ask them to change their mind, they probably won't. Somebody put in the chat box, do y'all know about us being able to get more units a week? 6 units a week is barely getting by. The price on wax is insane.
So
yeah, you probably can address that, huh?
Yeah, so that's definitely a law issue. So that won't even be touched until next year. The way that the law was written, under Initiative 65, we would have had effectively 9 or 10 units a week, and then it became 8, then it became 7, then it became 6 as our legislature tried to make it more and more conservative with less access. The more patients we can get requesting higher units, and I'm talking about card holding patients, to their legislator, the better. If anybody needs help with channeling of who to go talk to, if you live in, a certain part of the state and you say, I don't even know who to tell I'm having this problem, or who your patients, if you're a dispensary owner, who to tell them to call, I'm happy to help direct them to the right people. But the number one way we can get that fixed is if the people who write the law understand that it is insufficient in its current form. 6 units a week is not enough, especially when you look at the potency caps on top of that. So it just creates a very, trying to make a puzzle with very, very weird jigsaw puzzle pieces to actually get patients relief. It is happening, but it's not happening to the level that it needs to. So please send me an email of where you are, and we can kind of coordinate how to get people in your area talking to their legislators. For those who don't have it, my email is ken@medicalmarijuanams.com.
Somebody asked a question. Ken, let me address this one. It says, do you have to buy seeds and clones from Mississippi only? Great question. This has been a hot topic from the beginning when they had that arbitrary date in the regulations early on about having to have it all input into metric by, I think it was like September 1st of last year. And that date came and went. And then they told us it would be kicked out at the end of December, but we never saw that in regulations. And then they tried to approach it a different way in the spring. We never saw anything in writing. most recently, and this will be, I've been told, I feel like I can say this on good authority, that this is going to be addressed in this new batch of regulations coming out. What I believe to be the new regulation will say is that, yes, clones you'd have to buy only Mississippi from a licensed cultivator, but seeds don't fall into that category, and you can get seeds from anywhere. So that's what I think is going to be it. Ken, you want to add some commentary there?
Yeah, I want to add another further complication of that. So that is maybe what's going to happen, where clones can come and clones can't, seeds can come from anywhere, but depending on the way that the new farm bill gets written, seeds, there's a lot of anticipation that seeds will also be off limits, so it would have to be from a Mississippi company, but that's more of a federal restriction in the way it interacts with the state restriction. And it will be probably about 2 months before we have any understanding or clarity on that. So as of right now, the safest thing to do is buy from a Mississippi company if you have that relationship. But there might be other ways coming down the pipe.
Somebody said, what are some of the common SOPs that are being violated? So the ones that I've seen the most are anything related to tagging and inputting things into metric specifically, right? Like, I don't think a lot of people's SOPs initially went into that kind of detail when you wrote SOPs on the front end. You didn't really, I mean, a lot of my clients, they weren't even allowed into metric yet. So they wrote SOPs that were like, yeah, we're going to follow the regulations with regards to inputting into metric, but didn't really know what that was going to look like until they got licensed and then got into metric and saw like, oh, this is how you actually do that, right? So I would say that's one to go back and review anything related to that and make some revisions there. Record keeping is going to be a huge one. You're supposed to keep lots of records. The regulations are very clear about, employment records and about sales records and things like that. And so that's an easy one for them to ding you on. I don't know if they will, but keeping records is not fun. Nobody wants to do that, but that's an easy one to get nicked on. I don't think it's happening quite yet, but I anticipate that happening pretty soon. Those are the first two that come to mind. All right, we got one that says, Ken, this may be for you. Why do we have a week and a 30-day rollover? Like, why do we have both? Just my initial thoughts there is that we have a agency that wanted to be in a law that wanted to be fairly restrictive out the gate. I think people were concerned, right? They're concerned people are going to be buying too much, and so they really tamp down, right? It's out of the gate. It's very restrictive. Well, now we're kind of getting into it, and the sky isn't falling, and it's we're realizing, okay, that's actually causing more problems than it's helping. So now it's sort of time to ask for a little bit more leeway. But we had to get into the business first before they allowed us to do that.
It's pretty much exactly what Connor said, which is there's it was fear of the people writing the law, that they were fearful that the program would get too big, too fast, and too rampant. That is very, very clearly not the case. The good news is that a lot of the folks who oversee this at the Departments of Health and Revenue, the 6 units a week versus 24 a month is headaches for them as well, because they have to be tracking it. And I mean, metric does an okay enough job, but it only refreshes so often. So it would be easier for all parties if it went to a 30-day window. We are the only state that has a 7-day window. I think there are a few that have a 14 or a 15, but they don't have a 30-day as well. It's just, everybody's window is set. We're the only one, I think, that has 2 simultaneously. So I definitely think that can be corrected, but it won't be fixed until the law is readdressed in January.
That one is, I think, very approachable, because if you make the argument about medicine, right? We don't make people go back to the pharmacy every 7 days. And as they start to see that that's not really an issue and we treat it more like medicine, then they can start to kick that out a little bit farther.
And there are plenty of people who mention the price of cannabis versus prescription drugs, because there's no insurance to kind of cover the difference. And another hidden cost to all of that is travel. You got a lot of people who are driving an hour, hour and a half to get to the dispensary that they want to, for whatever reason, because the places in between opted out, or they have a certain product that works best for them. So that, if you drive an hour and a half there and back, it's 3 hours in the car every week just to get your medicine. It would be a lot easier to do that once a month. So I feel very confident about it because the arguments to remove it are very strong, and I haven't heard of anybody who likes the dual thing, the dual allotment problem. So in terms of the squeaky wheel getting the grease, I think that one will get grease. The only issue is that it's in the law, not in the regulation, so it'll take longer to correct. And then is there patient demand of 1% of the population of Mississippi as patients? We are quickly approaching 1% of the patient population in Mississippi. I think we're on pace to do it by the end of October, where 1% of Mississippi will be a cannabis card holding patient. Connor, I think we're kind of getting to the end and it's almost lunch. So how can people get in touch with you if they have any questions?
You can shoot me an email. I'd say if you can't find my email or write it down quickly, I work for a firm called McLaughlin PC. So you go to McLaughlinPC.com. That's McLaughlin PC.com. But also my email is just Connor@McLaughlinPC.com.